Supreme Court's in the news usually for all the wrong reasons this time this time around, and especially as we're waiting for the last gasp of new orders and decisions to come out before they take their summer holiday. We've got something that's very troubling that's going to start the new term in October, but we want to focus on it now. It's a voting rights case, really a voter suppression case that the Supreme Court has decided they wanted to take up, and it gives me the heebie-jeebies that they are lifting up the hood on that particular case. We break it all down for you on Legal AF, the podcast, and here's a clip. Karen, let's round it out with the Supreme Court. They're trying to go on holiday and get everything issued before the end of June. They're running late primarily with issuing their orders, primarily because of all these emergency applications that they're entertaining. They could fix that by stop entertaining them, but they never saw an emergency application they didn't like, and they keep taking them. But it's delaying them from issuing these 30, 40, 50, 100-page decisions that we're used to. Just as a reminder or new knowledge for people, we have tens of thousands of cases, state and federal, that happen every year. A very small percentage, very, very almost infinitesimal, end up at the United States Supreme Court. They only take about, it seems like more, but they only take about 60 or 70 cases for full-blown decision-making.
That's out of 7,000 or 8,000 applications. They take 70 or 80.
Oh, yeah, even when they get there. But there's tens of thousands of lawsuits in the country. So by the time it gets there, it seems like more, because, there's other things like making decisions by not making decisions, like refusing to take up a case, refusing to block a case. So if you add in, maybe we make it a couple of hundred lawsuits that they weigh in on during a given year, as you said, against 8,000 or 9,000, 7,000 or 8,000 that are actually filed. So justice in this country at the federal level, primarily, and at state court, is done at federal appellate courts, if it gets there, trial court levels, and state Supreme Courts, or the equivalent of lower level appellate courts in states. That's where justice is done. On some key constitutional issues, or something where the Supreme Court, now run by the MAGA side, are trying to make new law. You'll see a couple of more cases taken, but that's it. And so they owe us a lot of written orders, and we're waiting on pins and needles on some of them. And so end of June, hopefully they'll have them all out. That's the plan anyway. Then they all go away. The Republicans all go to these, used to be Federalist Society paid junkets. That's the weird thing about the whole thing, because every one of those MAGA right are Federalists. They all go to the George Mason, Antonin Scalia School of Law, supported by Leonard Leo, and they go on these junkets and hunting trips and fishing trips and Europe trips and golf trips paid for by MAGA money, by Federalist Society money. They do that all summer, and they do some writing and speech giving and all of that. And then they come back, in September to get ready for the first Monday in October, which is the start of the new term. Along the way, this is going to be a busy summer, because we're already up to, what are we up to now? Almost 5 months of the Trump administration. And we already have 17 or 18, let's say 20 emergency applications. So 4 a month, that's going to be unabated. We're going to have 4 a month through the summer, another 12 or so that they're going to have to decide on. Generally without oral argument. That's the problem with emergency applications, as the judges have often said in their own decisions. It short circuits their process. It puts a skeletal record in front of them with improper briefing or insufficient briefing, no oral argument, and no time to deliberate. And that's why we get these paragraphs, where the dissents and the concurrences are longer than the opinion. And so we had one of those, or 2 of those, in Rhode Island, about high capacity magazines, the thing that feeds into weapons, that fires off lots of bullets. And then we had a same day ruling by the court. And it looks to be, to me, 7-2 on both, which is very, very interesting. What did you make of the Maryland AR-15 block for now, Kavanaugh's statement? And then, we can just touch on the Rhode Island matter as well.
Yeah, I mean, there's a lot going on in the Supreme Court, right? You've got the Bost versus Illinois State Board of Elections case that they are going to take up, which has to do with election officials who who want to be able to count mail-in ballots that are received 2 weeks after election day, after as long as they're postmarked. But Boast is a member of Congress, and Boast, along with a couple of electors from Illinois, are challenging that, saying you can't do that. You can't make a law in Illinois that says that. It has to be by that date. And I think it's going to be very interesting to hear where the court stands on this, because as you said earlier, it's really up to the states to determine the time, place, and manner of federal elections. It's actually a doctrine written in the First Amendment. It basically says that governments can regulate the when, and the where, and the how of expressive activity, but not the content of the speech as well. So it'll be really interesting to see. I mean, I've always interpreted that to mean that it's really states get to determine that completely, right? And so if they want to be able to have mail-in ballots, as long as they're postmarked by a certain day, as long as they are received by a certain day, et cetera, that should be perfectly fine. And in fact, that's what's been going on all across the country for decades. You've got military people overseas who are doing mail-in ballots. You've got students who are in school in other states who do mail-in ballots. You get all kinds of individuals for whatever reason. People who live in red states who are afraid to go to the vote to a voting poll. They would prefer a mail-in ballot. I mean, there's many reasons why someone might want to do it that way, or vice versa. You live in a blue state and you want to vote red. I mean, there could be many reasons why someone just does, or whatever, you're unable to actually go in person for any particular reason. You could have a physical reason, et cetera. So it'll be interesting to see what they do with this and why they're taking up this case. But this is going to have huge implications for elections going forward, potentially on whether states can regulate this, because for whatever reason, mail-in ballots have typically gone blue. And that's why this is so on the radar of MAGA and Trump, because it's the mail-in ballots that tend to be more Democrat voters and less Republican voters. And so it's hard to call elections on election day, because some elections that are close might look like they're going red, but they haven't counted the mail-in ballots yet. So this is sort of a bee in the bonnet of MAGA, and something that they would love to be able to chip away at, frankly, and get the Supreme Court to rule in their favor. Now, the question I have for you, Popok, is do you think the court here is going to rule on the merits or on just the issue of standing? Because I know the issue in the lower court was whether or not the Congressman Boast had standing to bring and challenge this suit, and that was the issue that they ruled on appeal. Or are they going to resolve the bigger question about mail-in ballots? What are your thoughts on that?
Well, it's a good question. I mean, the Fifth Circuit Court of Appeals and Judge Ho and Oldham have been pushing for the Supreme Court to make a ruling in their favor, the way they see the law, that would deny the ability to have mail-in ballots come in after, certainly that far out after the actual election. Remember, this is the postmark date that matters. This means the voter's intent is clear. They voted. It's in the envelope. The envelope is marked the day of the election or before. It just shows up late. I mean, does anybody really trust the U.S. Postal Service, especially in the hands of Donald Trump and the Trump supporters? And so this was a reflection of that in rural areas and mail issues. Mail gets stuck in a sorter, gets stuck in a bag, a dead letter office, and your right to vote has been compromised or undermined. Part of me thinks they're taking the case because they want to say, even in the case of a 12-day out deadline, we're okay with it, as long as the voter's intent is clear and he voted effectively by envelope before the election. So if they get rid of it on standing ground, they don't want to touch the issue, and they're ultimately okay with the plus 12, at least in terms of the voting.
But then why take the case, right?
Yeah. Well, that's a good question. I mean, sometimes they take the case even when standing is poor to signal to the rest of the world that they want a better case brought to them, which brings us right that where they're not going to overlook standing. because it's important to them that there be Article 3 standing for somebody.
Why don't you explain what standing is for everybody?
Yeah, well, in order for you to prove to a court that there's a live case or controversy, because they don't make advisory opinions. Like, hey, I wonder if, I'd like to get an opinion from a judge about my dispute with my neighbor, or the neighbor across the street. Like, well, how are you impacted by that? Well, no, I'm just curious. Well, the courts don't do that. They don't scratch your curiosity itch. There has to be what's called, and this is a term of art, a live case or controversy. And one of the ways to ensure that there's a live case or controversy, that it's not an advisory opinion, is to ensure that the people before them have standing, or the plaintiff has standing in particular, to prosecute the case. They have unique injuries. They have a unique claim against them, whether it's a constitutional breach, or it's a breach of contract, or it's a tort, a defamation, personal injury, whatever it is, that they're not so attenuated. They're not such a drive-by plaintiff that they don't have the ability to properly bring this live case or controversy in front of a judge. He or she has to have in front of them two competing parties in our adversarial system of government, both advocating, and then when the judge rules, that there be a real result. That's why you also need you need all necessary and indispensable parties in front of the judge. Because if he or she's about to make a ruling that's going to impact somebody's rights, they need to be in front of the court. That's another kind of flip coin of the standing issue. And it's a way procedurally for courts who, especially the Supreme Court, which considers itself a court of limited jurisdiction, to, as you said, to take those 9,000 cases and get it down to like the 60 or 70 they're going to rule on. A lot of the times they do it by way of standing. They're like, well, it's interesting what you're bringing up, but you're the wrong party to bring that up, because and we know you're the wrong party, because if we rule in your favor, while it may be a declaration of rights, they're not your rights. Because the underlying theory is the person who's really being injured and has unique injuries is going to be the best person in our adversarial process with their lawyers to advocate for the position. Because if you're just sort of weak-kneed about it, because it's like, well, it's not really my issue. It's really like the noisy neighbor that's 16 blocks away, the neighbor next to them. That's the one that cares about the band in the backyard. Yeah, you could hear it down the street, but is it really are you really going to be vociferously prosecuting your case? Unless you are, if you're the neighbor next door. And that's sort of that standing issue. So we'll have to see. I don't know enough about it from the briefing standpoint. I think there may be a split vote about how to resolve this particular case. We call this kind of clip After Dark because we're using it to continue to grow our audience and also to bring onto Legal AF, the YouTube channel, make it a one-stop shop for all things law and politics. If you're on Legal AF, the YouTube channel, take a minute, hit the subscribe button as we continue to grow our audience there. Go on to Legal AF, the podcast, and download the audio. We need help there as well to continue to grow that top show. Without you, we're not top of anything. We're at the bottom. And that's why we need your support, your passion, your enthusiasm. We need you to be part of our movement and to let your friends know about it and bring them on as well as we organically join. While you're on Legal AF, subscribe. While you're on MeidasTouch, subscribe. We got a new Legal AF Substack, Legal AF the Substack. Subscribe there as well. You'll get your hands on all these all of these filings and all the courtrooms of the things we talk about, along with some expert analysis. So until my next report, I'm Michael Popok. Can't get your fill of Legal AF? Me neither. That's why we formed the Legal AF Substack. Every time we mention something in a hot take, whether it's a court filing or a oral argument, come over to the Substack. You'll find the court filing and the oral argument there, including a daily roundup that I do called, wait for it, Morning AF. What else? All the other contributors from Legal AF are there as well. We got some new reporting. We got interviews. We got ad-free versions of the podcast and hot takes. Where? Legal AF on Substack. Come over now to free subscribe.